Welcome here to the University of Illinois, Chicago.
Woohoo!
Yay! We're so glad that we could be one of the hosts for this amazing event, and we can see the great interest right now in these consent decrees because they are so important to what's happening in the field right now. I'm especially excited because this is really an example of bridging aging and disability, something I've worked on most of my career, along with Alan Factor, who's sitting back there. And we're finally seeing that some of this is happening. I will tell you that just yesterday I came back from Washington at a meeting at the Administration on Community Living, and we were presenting a webinar in regard to health promotion, and it was the first time that different branches came together from the Administration on Aging, the Administration on Developmental Disabilities, their policy and evaluation, and also their research arm, which is called NIDLR. So it's really exciting to see that it's finally happening. We're starting to see the many common interests. CJE SeniorLife has been very interested in this for a long time. About 20 years ago, they started the Linkages program that we worked together with them, and I know Brian Grossman is working from our end on that, and it's really a product of this collaboration. I just want to say a couple things about our Institute on Disability and Human Development, and I know there's some brochures in the back on that and what we do. What's most exciting that I have to tell you is that we've been developing an undergraduate program in disabilities, and so far over 800 students are taking our classes. We're really trying to raise the awareness of disability issues in the whole community. It's been an interesting year in Chicago with the ADA 25 and the many activities that have been happening in Chicago. We are really excited to be a part of this and really trying to help move Illinois forward in this difficult year, I would say. And without these consent decrees, I think things would be even much worse for the populations that we're talking about. So I hope you really enjoy the day and learn a lot, and thank you for coming.
All right, I'm going to start us off with a few housekeeping issues. First of all, I know there were signs in the front, and I know there are signs around the room, but I want to make sure everyone sees the obvious camera in the front of the room, as well as a camera over here on the side. And I want to point out that Cable Access Network Television is in the room and is filming. We'll be filming the entire program. This camera is going to be up here on the speakers and on the panel. Scott also has a camera. Scott will ask you if he can take your picture if you're in the safe zone. If people absolutely don't want to be photographed, be sure you're sitting in the area that's marked for not photographing. Just so you do know, if you want to see the program later, it will broadcast on Adaptive Chicago Productions, which is on Channel 19, and it will also be available on YouTube. Before the first speaker starts, I want to make sure that everyone has completed and turned in a blue survey. This is our pre-survey to kind of measure the impact of our presentation today. So this is very helpful. If you can turn it in and put it, either give it to Brian who's walking around the room or put it in the back of the room in the basket. My name is Roseanne Corcoran. I'm delighted to introduce our program today. I'm manager of community counseling and the Linkages program at CJE SeniorLife. Linkages is a program that provides support, information, and referrals to seniors who have adult children with disabilities. For almost 20 years, as Tamar mentioned, Linkages has been in the position of helping families navigate both the aging and disability network systems in Illinois. That in itself is a phenomenal task. Our initial speaker and the panel will highlight the benefits and obstacles that have been experienced in implementing the Illinois Consent Decrees. In addition, this program will address how important it is for each of us to understand what's happening in the aging and disability service systems in our state and how each of us can become more effective advocates. This is our 4th year offering this program, and we offer it during the month of February because this is Jewish Disability Awareness Month. We anticipate gathering for a similar program next year, although it certainly is on the table whether or not it will be in February. And those of you who were with us last year, recall going through a blizzard with about 10 inches of snow. We were in near miss today, although we are here and safely in the room. Please be sure in those evaluations at the end of the program to let us know if you have ideas for our topic for next year's program. I want to take a moment to acknowledge and thank the agencies who are sponsoring this program today. Among them, of course, are Tamar Heller and the University of Illinois Chicago Department on Disability and Human Development, as well Access Living, the ARC, CJE SeniorLife, the Center for Independent Futures, Encompass, Jewish Child and Family Services, JVS Chicago, and Keshet. I would also like to introduce and thank, I'm not going to introduce you all by name, but I want to introduce the Planning Committee. Planning Committee, Tammy, Brian, hold up your orange tag so you can tell a Planning Committee member because they have one of these delightfully obnoxious colored name tags on. You can ask any of us for information, any assistance that we can provide. We are happy to. In an effort to honor the value of access and inclusion, please let any committee member know if you need assistance in any way throughout the program.
Ma'am,
Yes.
you've got some blind people here. We don't see who the people are. So why don't you have each person talk so we know who it is?
I could do that, certainly. The issue is, as I asked them to raise their name tags, they're all actually running around the room. So locating them in the room, they're not in permanent positions. But if we could take a moment. Scott, do you want to start and introduce yourself?
I know Scott.
Hi, I'm Scott. Scott from Access Living.
Tammy?
I'm Tammy.
Brian, where are you?
Brian.
I know Brian.
Any other planning committers in the,
Alan.
and a few other people are out in the hall and also out in vans and running to try and help transport folks. An incredible team, I have to say, and many of these folks who are introducing themselves are also on the Linkages work group, and I could not do my work without them. They're just an incredibly wonderful group. I do also want to mention program agendas are in the blue folders. Anyone doesn't have a blue folder, there are extras back on the table against the wall. That agenda will guide you through the day. There will be one 15-minute break at 10:50. Restrooms, if you haven't found them already, the women's room is up here in the front of the room. There is also a gender-neutral restroom up here, which I have noticed is not accessible. There is a men's room out in the hallway back by the elevators.
Do they have Braille on it?
Excuse me?
Do they have Braille on it?
Scott is checking that. There will be a question and answer period after each speaker. Please write down your questions on the cards that are on the table. So there are note cards on every table. This is in an effort to keep our questions as focused as possible. So what we will do is collect the cards. We're going to be prompting you through the program to write your questions down. Hold the cards up when you've completed it. If you need assistance, certainly please do ask for assistance, and a committee member will help you write out your question. We will then be collaborating with the questions and honing them down so that we ask the questions that are the broadest and most inclusive of the issues in the room. I will say that in the interest of time, we're going to have to keep the program moving. The bathrooms are in Braille. So the interest of limited time, we're going to review the questions, select those that are the most broad and inclusive. We will obviously not be able to read every question in the room, but we'll do our best to answer questions as we can. If your question is not answered before you leave, please approach a committee member and let us know how we can help. I do want a really important announcement. We have run out of regular coffee. We have plenty of decaf coffee, plenty of water, and plenty of orange juice. Is there anyone in the room that feels it's an absolute necessity that we run out for coffee? That's what I thought. Meredith was ready to jump in her car and go, and I stopped her. So I think we'll be fine. I do want to now move on and introduce our first speaker. I want to point out that my introduction is going to be brief because there are actually more full bios in your folders. So please refer for more information to the biographies in your folder. I do also want to say that folks with limited vision or who need Braille, we are sorry we don't have that information with us today, but we will work with Scott to accommodate anyone's needs, and we'll have the information available at a later date and make sure you get it in whatever format you need. Our first speaker is Laura Miller. On our agenda, we had both Laura and Barry Taylor from Equip for Equality. We knew we would only get one of them, so that was kind of, Barry will be here in the room, but Laura is going to do the presentation. Laura is the managing attorney for Equip for Equality's civil rights team. She's responsible for supervising the legal work of attorneys and advocates on this team, which is involved in class action suits and has been involved in all of the Illinois Consent Decree legal work from its inception to present. They are currently litigating 3 cases to enforce the rights of people with disabilities to move out of institutions, and 2 cases to improve conditions of people with disabilities in the criminal justice system.
Yay.
Laura.
Hi, good morning. Can everyone hear me? Yes. Okay. Sometimes I'm too loud, actually, so let me know if I'm too loud. Am I good? Okay. Okay, so I'm going to talk about the 3 community integration lawsuits that Equip for Equality is involved with, and those are Ligas, Williams, and Colbert. And these cases are based on the premise that living in the community is not a gift, it's a right. As Roseanne said, we'll have time for questions at the end. If something is incoherent or you can't hear me or whatever, raise your hand and let me know, but otherwise we'll save the questions till the end. So I am not a PowerPoint person, but Roseanne told me I needed to learn how to do this for this presentation. So I've done my best, and I'm very excited that I do have some pictures in my slides. Okay, but I'm not sticking completely to the PowerPoint presentation. I might deviate from it a little bit. So I just wanted to start by talking a little bit about the history of institutionalization in the United States. So from about 1850 to 1960, large institutions were really the norm for people with psychiatric and developmental disabilities. And some of the people who supported the development of these institutions were well motivated. They thought that people would go to the institutions, get education, get vocational training, and then return to their home communities, better equipped to be integrated. But by the late 1800s, the institutions had really become a nightmare. So we saw abuse and neglect of residents and dirty, unsanitary conditions, widespread disease, very little education, very little vocational training. And in fact, it was really, there was a lot of forced, unpaid labor as the heads of the institution sort of competed for who could run their institution more cheaply. And we also even saw forced sterilization in these facilities. And when I was preparing for this, I found a good quote, and this was about the original planners of the Northampton State Hospital from Massachusetts. And she writes that they thought it was going to be a great place, a real contribution to human happiness and fulfillment, and it all went bad so quickly. And on the PowerPoint, that's a picture of the Willowbrook Institution in New York, about which there were many exposés. So in the 1960s, because of these very bad conditions in institutions, and also the influence of the civil rights movement, people with disabilities and their families started really pushing for the right of people with disabilities to move out of institutions and to live in communities. And then in the 1970s, several good things happened on the legal front. Congress passed several acts to protect the rights of people with disabilities, and these included the Rehabilitation Act, which said that entities that receive federal money can't discriminate against people with disabilities. That was a very important law, and we still use that law every day in our office. And the other thing about the Rehabilitation Act is that it had a regulation that said services must be delivered in the most integrated setting, so that government services had to be delivered in an integrated setting. So in the 1970s, we saw a lot of lawsuits aimed at these really bad conditions in institutions. And several years ago, actually, Equip for Equality produced a report, and we went through each state and looked at the history of the treatment of people with developmental disabilities, and I read many of these lawsuits. And some were based on the Rehabilitation Act, and some were based on the U.S. Constitution. Now, some judges ordered improvements to institutions, and some judges actually ordered closure of institutions. And so, for example, if we look at the Pennhurst case, which was a very famous case, that has resulted in the closure of Pennhurst, and all the former Pennhurst residents are now living in the community. So all of these cases and laws and movements kind of made states start to think, oh, is what we're doing now right, or should we be moving in a different direction? And many, many states started moving towards community-based programs and housing. And so in the 1970s and 1980s, you saw a lot of people moving out of institutions into community settings all over the country, including in the Midwest. Wisconsin and Michigan were fairly early in the movement of people out of institutions into the community. And then in 1981, Congress really helped this whole movement along by saying the money that we give states for Medicaid doesn't have to be paid to institutions. It can be used to support people living in the community. And that was a big change, because prior to that, when states got money, it was to pay for institutions. And now Congress said, you can use that same money and you can support people in an integrated community setting. So then in 1990, another good piece of legislation, the Americans with Disabilities Act, and that sort of extended the protections of the Rehabilitation Act to the private sector. So it extended them to non-recipients of federal funds. And when Congress passed the ADA, there was some really good language. Congress found that isolation and segregation of people with disabilities is a form of discrimination, and also that institutions diminish the quality of community life. And like the Rehabilitation Act, the Americans with Disabilities Act also had this really good regulation, and it says that states have to administer services, programs, and activities, again, in the most integrated setting. So, and then following the passage of the Americans with Disabilities Act, there was a case from Georgia about two women who lived in an institution, and this case went all the way up to the United Supreme Court. And the court confirmed then unwarranted institutionalization is a form of discrimination. We usually think of discrimination as comparing people, comparing what women earn at work to what men earn at work, and if women earn less, that would be a form of discrimination. But this was the first time that the court said, no, that's not the only kind of discrimination. It's not just comparing a disabled person to a non-disabled person. It's when a disabled person is unfairly separated from the community at large. So that was a great decision. And again, most states using all the laws that I already talked about, and now the ADA really, beefed up moving people out of the community. So now we come to Illinois. So unlike other states, Illinois had really failed to move people out of institutions and into the community. And about, let's see, I've been at Aquifer Quality 15 years. About 12 years ago, we really started looking carefully at the long-term care system in Illinois, and we found some very disturbing things, and those findings sort of formed the motivation and basis for our bringing these lawsuits. So now this is, again, looking back 12 years. Illinois still had about 10,000 people with developmental disabilities in large institutions. Some of these were public institutions called state-operated developmental centers, and then some were private but publicly funded institutions called ICFMRs or ICFDDs. And there were almost 300 institutions for people with developmental disabilities, ranging in size from about 12 people to about 600 people. And we visited many, many of these institutions. Our staff went throughout the state. We had experts going with us, and we found lots of poor care and lots of just idleness, lack of activity, lack of stimulation for people. And also at that time, and unfortunately this has not improved too much, but Illinois ranked last of all states in the District of Columbia when you look at the number of people living in settings between 1 and 6 people. So basically, we were last when looked at our people living in integrated small settings in the community. So, and we also looked at people with mental illness and found equally bleak conditions. Oh, I think I'm way behind now. Hold on. Oh no, I'm okay. So there we found about 4,000 people, between 4,000 and 4,500 people, living in 30 institutions called, very offensive name, but institutions for mental disease. And these are nursing homes in which more than 50% of the residents have a primary diagnosis of mental illness. And interestingly, the state was investing heavily in these because they did not receive a Medicaid match. Medicaid will not match institutions that are over 50% people with psychiatric disability. So these were 100% state supported. And we visited all the IMDs, and again, very little to do. There would be classes in stretching and current events, but very little activity. Short, infrequent meetings with psychiatrists, very little group work, and also just the physical conditions of these facilities were really dreadful. And none of this really was conducive to the notion of recovery. Living with not very much to do, usually in facilities that had very little sunlight, very little stimulation. And then we found thousands more people, some with mental illness and some with physical disabilities, in conventional nursing homes. Oh boy, only 10 minutes. Okay, and I've not gotten to talk about the cases yet. Okay, so we looked at all these facts and we looked at the legal tools that I just talked about, which were, case law, the Constitution, the Rehabilitation Act, the Americans with Disabilities Act, and we decided to bring 3 cases. And I really want to emphasize that Equip for Equality did not do this alone. We worked with Access Living. We had a large law firm on every case. We worked with the ACLU. So these efforts were really big group cooperative efforts. These cases are incredibly resource intensive. Even after the consent decrees, I work on the Ligas case every single day, and the consent decree is now 4 years old. So, okay, so we'll talk first about Ligas v. Merrim. It was Merrim at the time it was brought. And you'll hear from Stanley Ligas in a few minutes. But this, okay. There we go. Okay, so this suit was filed in 2005 by 9 individuals, and Stanley was the lead plaintiff. And they represented a class of people living in private but publicly funded, Medicaid funded and state funded ICFDDs. And these ICFDDs ranged, as I said, from 9 all the way up to hundreds of people. And so the class consisted of about 6,000 people living in these facilities, and then thousands more people who we call at risk of institutionalization, people living at home but in settings that were not stable. For example, they might have a parent caretaker who was ill, or their parents might be very elderly. So the court certified the class, and we reached a consent decree with the state, and it was a great consent decree, and everyone would be evaluated for community placement, although no one would be required to accept it if they didn't want to. So anyway, we had a fairness hearing in July of 2009, which I always say was the worst day of my legal career. And there were over 2,000 guardians, not a single person with a disability, but 2,000 guardians who objected to the consent decree. They said they wanted to keep their family members in institutions and felt that the consent decree was trying to intrude on that choice. And they said that even though there was nothing in the consent decree that required people to move. So the judge was very affected by this, and not only did he not approve the consent decree, but he went a step further and he decertified the whole class. So now instead of representing like over 10,000 people, we were representing 9 people. And the judge instructed the parties to return to settlement discussions and to include the guardians who objected to their loved ones moving out of an institution. So then after more than a year, we had a new consent decree. That consent decree was agreed to by the guardians, who were now called interveners, and then the judge approved it at a fairness hearing. Oops, I'm behind again. So what does this consent decree provide? So it provides that everyone who's 18 or older who has a developmental disability and lives in a private ICFDD with 9 or more residents, so we're focusing on larger settings, or lives in the family home and is seeking services and wants to move, okay? So everyone who lives in an ICFDD can move if they want to during the period of this consent decree. If 100% of people want to move, then the state has to move 100% of people living in ICFDDs. So that's for people living in the ICFDDs. For people living at home, 3 important things. For people in crisis, there used to be a limit as to how many people in crisis the state would serve. Now there's no limit. If you're in crisis, you get services within 72 hours to alleviate that crisis. For people who are not in crisis, the state created 3,000 new service slots for people who are living at home. It's not enough because we have way more people than that on the waiting list, but it's 3,000 more than we had before. And then after the 6th year of the consent decree, and after all the 3,000 people have been chosen, then other people get to move off the waiting list at a reasonable pace. So, good news is that more than 5,500 people have received services under the consent decree. This includes people who have moved out of ICFDDs, people who are at home with family and are getting in-home services for the first time, and then people who have moved out of the family home into community-based placements. Okay, so I just want to go over some of the concerns that we have about the implementation of the decree. So community settings are larger than we'd like to see. A lot of people are living in homes with 6, 7, or 8 people. We'd like to see more people living in the type of settings that they choose, and most people choose smaller settings. So we'd like to see people in 1, 2, 3, and 4 person settings. Community settings are often further away from families that people want. So a person might want to live, let's say, within 10 or 15 miles of their parents. They end up living 60 miles from their parents. And their parents might be getting older and unable to drive that distance. So again, we want to see homes that are closer to where people want to live. There's a very serious problem with a lack of customized day programming. The last thing we want to see is someone moving from an institution into a community setting and then being told, you have to spend all day in a sheltered workshop, or you have to spend all day in a day program. We want day services to be customized to meet people's needs. And then finally, there are people for whom we've had difficult time finding providers. These tend to be people with more complicated medical conditions. And I just wanted to mention that our new monitor recently found the state out of compliance because of the underfunding of developmental disability services. If we had more funding, there would probably be more settings that would be customized to people's needs. But instead, we have underfunding, low wages for workers, and a lot of providers can't even recruit workers at low wages. So, for example, the state pays about $9.50 for DSPs in the DD system. That's contrasts to $13.50 for people working indoors home services, and then $17 to $25 if you're a DSP in a state op. So we're working with the state to try to resolve this issue. If it's not resolved, it will be decided by the judge. Okay. Now, do I have like negative 2 minutes now? Okay. Okay, so on behalf of people with mental illness, we filed a suit called Williams versus Quinn, and this was about the people I talked about earlier, people in institutions for mental disease, about between 4,000 and 4,500 people. Those were state-funded facilities, no Medicaid match. So in that case, the parties reached an agreement in 2010, and even though 1,000 people objected to that consent decree, a lot of the objections were from guardians and also owners of the IMDs. The judge in this case said, I still think the consent decree is fair, even though there are these objections, and that judge approved it as it was. So in this case, the residents who don't oppose community placement get to move into the community within 5 years, and the presumptive placement is permanent supportive housing. That's considered the most integrated setting for the vast majority of class members, and that's generally integrated apartments in the community. And now the state will get a 50% match for many of the services that previously the state had to pay 100% for. So again, very good news, almost 1,500 class members have moved into the community. We are having some implementation problems, as we have with Ligas. There are some people who are considered hard to serve and have not been allowed to move into the community. And as people are moving out of the IMDs, new people are moving in, and we really want to see the front door closed to the institutions because they generally are not consistent with recovery. And then finally, the final case, Colbert v. Quinn, now Colbert v. Rauner. This is for people who live in nursing homes in Cook County. This is actually the largest. Well, it's probably about the same size as Ligas, actually, but it's over 16,000 class members. Some people have mental illness, some people have physical disabilities. The consent decree was approved in 2011, and then in the first 30 months, a deadline that the state didn't meet, but the state was obligated to move 1,000 people into the community from nursing homes, but now they have, it's about 1,100. And then if these placements are found to be cost neutral, which we expect they will, meaning that they will cost no more than the cost of the person living in the nursing home, then the state has to come up with a plan agreed with by the plaintiffs and the court that will allow other class members to move out. So we have come a long way in the last 10 years. We still have a long way to go. And I think just the important takeaway is that community living is a right of every person in Illinois. And when every person with a disability who wants to live in the community finally gets to realize that dream, Illinois will be a much more inclusive, diverse, rich, and interesting state to live in. So, sure.
And we do have questions collected. If anyone still has a question, please make sure to hold up a card so we can get that in. Alan is going to read the questions that we've already collected. And our panel can start to set up.
Can Alan read them up here?
Yeah.
And can Alan read them up there, please?
Alan, can you bring
At
them
the
up
podium,
front?
please.
And if I don't know the answer to any of the questions, which is quite possible, I'm happy to find out the answer for you, and we can figure out a way to communicate it to people.
Is that not working, Alan?
No, I may not be on.
Okay, here, you can use mine.
Thank you. Okay, everybody can hear me? Okay, first question, Laura. How are residents being informed of these rights to seek services to move into the community, into community settings? And can you answer this for all three consent decrees, please?
Okay. That's a very good question. All three consent decrees do require outreach to the class members to inform them of their rights. I have some concerns about some of the outreaches that has been done and the effectiveness, and that's one of the things we're looking at, because we don't want the consent decrees to wind to a close and people haven't even been informed of their rights, so they haven't been able to elect to move into the community.
Thank you. The second question, what is considered a reasonable pace for moving off the waiting list, getting into a community residential setting?
That is also a great question, and that actually has not yet been determined. That is something that we're going to negotiate with the state, and again, if we can't reach agreement, that will go to the judge. The interesting thing is, at least for the, sorry. So the interesting thing is that in Ligas and Colbert and Williams, in many instances, when people move out of institutions, the state, either, it's cost neutral, or in some instances, the state saves money. So I'm not sure why there would be a reluctance to continue moving people at a vigorous pace. Now, with the people moving off the PUNS waiting list in Ligas, that is new money. In other words, many of those people are receiving no services now, so the state would have to add money.
Turn the-
Yeah.
Okay, I'll repeat that. When are the 3 consent decrees over?
They do have end dates, but, so for example, Ligas ends 2020, and Williams and Colbert, technically speaking, end soon, but then we will seek extensions based on the states not having complied with certain benchmarks. I did, one thing I did fail to mention, which is important, is that we went into court in the summer to get the court in each of the cases to order the comptroller to pay bills to the providers, because we had scores and scores of providers contacting us saying, we cannot meet payroll, and we're going to close this house where class member, like in Ligas, there's there might be a 4-person SILA and 2 people are Ligas class members, and the house would be closed. So in each instance, the judges did order the state to make payments, which was, I think, kept the service system intact. That said, it's still a very poorly funded service system, but at least people are getting the same money that they got last year.
Laura, is there a requirement that housing be close to the family?
I think so, yes, because both, if we're talking about housing for people with developmental disabilities, the SILA regulations in our state actually contemplate closeness to family and community. But beyond that, the cases require person-centered planning. And what that means is you don't say, oh, we know you want to live in Chicago, but there's an opening in Kankakee. Would you like to move there? Rather, person-centered planning is taking the needs and wants of the person and then crafting a setting around them rather than the reverse.
Now, when the governor talks about wanting to get out from under the consent decrees, what is he talking about? And is there a possibility whatsoever that he can do this?
Well, I cannot answer what he means by that. I don't know. The only way I know of getting out from under consent decrees is to fully comply with them. And then you can move that the consent decree be vacated because it's no longer needed because there's full compliance. But we are very, very far away from that. I guess I don't really understand being a public interest lawyer, the hostility to consent decrees. I think they've been really useful tools in many places and on many issues when government needs a little push to adhere to the rights that people have.
Okay, thank you. Those are all the questions we
Okay,
have, Laura.
all right, thanks very much.
And we do have a few more questions.
Oh, okay.
You were off of the hot seat.
No, I hope
Okay.
they're not harder.
once the state is found in compliance with the consent decrees, what will remain in place to ensure reinstitutionalization doesn't happen again afterwards?
Yeah, these are all great questions. I think that's a really important issue. Well, you know, one thing is that CMS has developed some good regulations for community settings that require that settings be smaller, more community integrated. So there are some good things happening on the federal side that will help us. But, you know, I guess what I would say is, you know, vigilance, voting and activism, and letting lawyers like me know when things are deteriorating or backsliding. But yeah, there is no guarantee. And actually, we are seeing in some states some reinstitutionalization.
Possibly the last question is, I'm worried about losing my SILA funding. Can, in fact, they take it away?
No, it's Medicaid funding, and they can't take it away. But if something like that should happen, if someone feels like they're being threatened with a loss of services, and we are seeing that with DOORS home services reductions. So if someone ever feels that they're losing any type of government services, you know, they should contact Equip for Equality or the Shriver Center or Legal Assistance Foundation and let us know so we can intervene.
Okay, thank you, Laura.
Okay.
Thank you very much. Wonderful. Excellent. Thank you.